an order of the court, and you have done the same thing as if, say, I'm representing a creditor, and I filed a dischargeability action, said don't discharge that debt. It's the same effect. That debt's not discharged, and your client remains liable on it. I don't think you'll ever see it again, but years ago, I started with Sears, and they were doing what were called informal reaffirmation agreements. And they would just have creditors sign something at the creditors meeting and said, I'm going to repay this. And it caused a huge national stink. They got in a ton of trouble. We designed some reaffirmation programs for Macy's and for Zales and some other major national retailers to tell them, never again do this, and you have to have a checklist, and the creditor has to do it right too. It's not just the debtor. So on those reaffirmation agreements, again, excellent question. I'll take Johnny's side here. You've got to, you can't quite tell your client no, but you need to tell your client the ramifications of signing that rehab, presenting it to a judge, and saying you're still liable on this, regardless of how hard you guys worked to get that discharge at the end.
It's highly regulated, and I'll just tell you, Section 524, it's a long statute, and you got to jump through a lot of hoops in order to get a enforceable reaffirmation. So you can go read it, look at the cases. Okay, Wayne?
Moving along, if you look at page 4.
And if you have more questions, interrupt us.
Yeah,
right?
please do.
We want to give you the information you need.
Your client's ability to receive a discharge is limited by time. If they received a discharge in a prior Chapter 7, they have an 8-year window, 8-year period where they cannot receive another discharge. As you see, it's the commencement of the first case to the commencement of the second case. They can't receive another discharge within that period. Same thing with the Chapter 11. There are individual Chapter 11s. I kind of doubt that the folks in this room are going to be seeing prior Chapter 11s, but hey, you might. Chapter 13 is a little different. If your client had a church, filed a prior Chapter 13, got a discharge, it's a 6-year window, but there's no time limit if they repaid all of their unsecured debts, or if they paid 70% of those unsecured debts and made a good pose in good faith, and it was their best effort. And that's a fact question for the judge to decide. Did they make a best effort? But they couldn't pay 100%, but they did pay 70%.
Just keep the papers. 1328F is where you look. You need to find out if your client has filed a bankruptcy before. Get their social security number, go on Pacer, search their social security number. You need to know this information, because if you file a case too soon after a prior discharge, they're not going to be able to get a discharge. Right? So it's really important. It's commencement to commencement, right? Filing to filing is all the time deadlines. I'm not going to go through, but there's separate deadlines for when the second case is a 13, right? You always look and find out what the second case is and see whether they're entitled to a discharge in the second case. And I'm not going to go through it, but it's commencement to commencement. 1328F is where you're going to look for a 13 for the second discharge, all right? You're always trying to determine whether your debtor is entitled to a discharge in the most current case. Always need to find out what their filing history is for more reasons than discharge. You always need to find out what their filing history is.
Because in that filing history, you're going to be able to get a copy of their prior schedules. And I'm sure you all know it, but if you Google Pacer Service Center, you can do a nationwide search. Because people move around. If they've got something on there and you're looking at their prior schedules, their statement of affairs, yeah, it was 7 years ago, but hey, what about this? You didn't tell me about this. It's part of due diligence. It doesn't take very long, but it's something you need to do.
Scope.
Go ahead.
The most common bankruptcy cases you guys are going to file are Chapter 7 and Chapter 13s. And again, the discharge is what you're looking for. And so it's also important when you interview your client to find out what kind of debts they have, because not all debts are going to be discharged. There are kinds of debts that are not discharged, that are not within the scope of the discharge of a 7 or a 13. All right, the 7 is kind of the standard. All right, that's where everybody kind of starts at what's discharged or not dischargeable in Chapter 7. We're going to talk about Chapter 13. Chapter 13 has a little bit broader discharge than in Chapter 7. It includes certain kinds of debts that are not discharged in Chapter 7. The most common, all right, is going to be the willful and malicious injury. And then down at the bottom, near the bottom of the page, that property division or obligation, non-domestic support type of debts are discharged in the 13, not discharged in the Chapter 7, right? So if you're interviewing your client and you run across non-standard kinds of debts, right, which is going to be student loan, IRS liability, some kind of judgment, if your client has a judgment against them, you need to read that judgment. Very important, right? Because fraud is not discharged. Willful and malicious injury is not discharged. So you need to know what's out there so that you can tell them this bankruptcy is not going to help you with this $3,000 judgment against you because it's for fraud, right? So the Chapter 13 is a little bit broader. It also is not going to discharge that. Read through it. We tried to give you the citations and one or two case examples. So if you run across that, follow up and look for it.
A small addendum to what Johnny just said. Your client's got the judgment that says it's for fraud. It doesn't automatically get accepted from discharge because I have been on both the winning and the losing side of prosecuting a dischargeability action where fraud was involved in a prior judgment from state court. The standards are different over here. The judges are going to take a look at it. If you've got a default judgment that just says fraud in it, it's likely that that's still going to be dischargeable in this court unless you completely retry your case and prove fraud in front of the bankruptcy judge. That's kind of getting far afield, but as in most of bankruptcy, there are few absolutes. So it's something that you're going to have to take a look at, just look at what the underlying judgment says, and go from there.
In 523 is the code section. Go to 523, and then 1328 for your Chapter 13 case modifies 523. Everything in Chapter 5, everything that starts with a 5 is going to apply to all your bankruptcy cases. Just remember that when you're going through the code. A few common exceptions to discharges. We'll go through fraud we talked about. You're going to look for your client has used his credit cards recently, all right? Yes, I went and got a $1,000 advance on my credit card yesterday. All right, the bankruptcy code and the creditors lobby has really, they've pushed on this hard. And so there's an exception in 523A2C that also provides for a presumption of non-dischargeability if this card has been used for luxury goods or you've gotten cash advances recently before the case. And I'll go through the details. These dollar amounts are wrong. They adjust. The 675 is really 725 and the 950 is really 1,000. Just be aware, and I'm going to do a few real quick. In the student loan, which is 5 minutes. The student loans also, student loans can get tricky. There are private loans out there that may not be covered by the statute. One also to know is the Bruner test. Student loans are subject to hardship discharge. That hardship discharge is, in essence, an impossibility, quite frankly.
Unbelievably tough.
It's called the Bruner test. There's a case out there, I think, at the Ninth Circuit or somewhere, Bruner. That's what everyone uses, the Bruner 3-step test, undue hardship. If you have student loans and you're going to try to do it, you need to do some work and go read that standard and try to marshal your facts to fit in there. What do you want to hit before we finish your Wayne?
Probably the personal injury or death and taxes, Johnny. I think those are both important.
All right.
Personal injury or death due to DWI, DUI, not making any broad generalizations, but you may see a client who's facing that they have had a DWI or DUI, and they come to you and say, I got hit with criminal restitution charges. Well, criminal restitution charges are not dischargeable. And there's a specific exception in the code for those. A broad swath of the population have had problems with this thing, and you may see one or two of them. That's part of that initial client interview that's going to be so important. Finding these things out. I want to discharge the DWI fines that I have. Well, there's answers. No, it's already in the code. You want your tax record?
Taxes, two things before we finish. We got about 3 minutes. Taxes are a very complicated issue, all right? But I'm going to give you some general rules. But if you have a tax issue, you probably need to talk to someone that really understands the dischargeability of taxes. Generally, if a return hasn't been filed for a particular year, that debt is not going to get discharged, number one. Number two, it may have to have been timely filed, not just filed. That's kind of an unknown. But if it hasn't been filed, that tax is not going to be able to be discharged. Second test is if it was assessed within 2 years prior to the filing of the bankruptcy. Assessed is a legal, technical IRS term. And so if they were audited and reassessed within 2 years, even though it was an old tax debt, it's not going to be subject to discharge. So general rule, if the tax was last due less than 2 years prior to the filing of the bankruptcy, that's probably not going to be dischargeable. If a return was never filed, probably not going to be dischargeable. And final thing, which is really important, is how do you get your discharge for your client in a bankruptcy case? Remember that there is a credit counseling certificate that's required to file. There's also a financial management certificate that's required to get their discharge, one of the requirements. And in Chapter 7, they're going to get it if they don't file that second certificate, all right? Really important. And in Chapter 13, you've got to file a statement indicating that your client, if he owes domestic support obligations, he's current and he's paid them, and he's made all of his Chapter 13 payments. So there is a form that has to be filed asking the court, or informing the court your debtor is now entitled to a Chapter 13 discharge. Please enter it. Chapter 13 discharges are entered at the end of a case. Chapter 7 charges are entered by the clerk, by the court, once the dischargeability deadline has run and no one has challenged that discharge of your debtor and you filed your second certificate, the court will just enter that discharge. Thank you, and I'm sorry
Last but not least, I commend your reading. I won't go over it. Page 12. A lot of your clients are going to have family support obligations arising from a divorce. You need to be aware of that in that initial interview because those are, for the most part, non-dischargeable. Be aware of that, and thank you.
Thank you guys for representing these people.
Absolutely.
And I want to add that don't ever be concerned about showing up in one of our courts. I know you heard it from Judge Isker, but our judges are all, not only will they help you to the extent they can, but you're going to be in a courtroom full of lawyers that are going to be more than willing to answer your questions.
Just ask any one of us.
Like Judge Isker said, you get the best consumer lawyers probably in the country in this district. So take advantage of it.
Thank you, Wayne. Thank you, Johnie. Before I introduce